I am Dr. Sudhnya N. Kulkarni, Associate Professor, Department of Philosophy, Janki Devi Memorial College, University of Delhi. Today's topic is capital punishment, issues and concerns, and this is something that I am going to be covering under applied ethics. As you can see from this particular slide, I have shown the different ways in which capital punishment is carried out across different countries. Before we begin to discuss capital punishment or death penalty and issues and concerns surrounding it, it is important to understand what exactly is meant by capital punishment. Capital punishment basically implies sentencing an offender to death after being prosecuted by law. The process that is implemented basically follows a rule-based format of procedures and laws to punish the offender or the offenders. Crimes that are punishable by death are often known as capital crimes, capital offences or capital felonies. The terminologies are different in different countries. They include serious crimes against persons, namely involving murder, aggravated rape, assassination, terrorist activities, genocide, crime against humanity, child murder, etc. If we go on to look at the origin of the term capital, we find that the classical Latin and medieval French roots of the term capital indicated a punishment involving the loss of head or life, maybe probably indicating the use of beheading as a form of execution. The actual practice of capital punishment is pretty ancient. We find mentions of it in the Babylonian Code of Hammurabi that included about 25 capital crimes. The Mosaic Code of the ancient Hebrews also identified numerous crimes that were punishable by death. Draco's Code of 621 BCE Athens also punished most crimes by death. In medieval and early modern Europe, we find a long list of capital crimes and forms of execution, which often included the practice of stoning, crucifixion, drowning, beating to death, or poisoning. In the Middle Ages, the authorities participated in executions that were designed to be brutal and included often beheading, burning alive, drawing, quartering, hanging, etc. Capital punishment was also pretty often conducted publicly, and death was shown or displayed for the public at large. In the late 18th century, with the creation of prisons where the criminals could be locked, the matter or death penalty or capital punishment started to be kind of getting reduced. Cesar Beccaria's essay on crimes and punishments, published in 1864, changed the manner in which capital punishment was being meted out to criminals, and he went on to introduce a new perspective regarding its effectiveness as a means of controlling crimes. As time progressed, the methods of capital punishment became less brutal. By the mid-20th century, especially in the United States, the Supreme Court challenged capital punishment as being cruel, biased, and even being mistaken at times. The Second World War and the 1948 Human Rights Charter of the United Nations made the debate against death penalty more vocal. Many countries today have abolished the death penalty, with some notable exceptions like China, North Korea, Japan, India, Indonesia, Egypt, Somalia, and the United States. The United States is the only Western industrialized nation that has death penalty. We will now consider two very different approaches regarding capital punishment. One is the backward-looking or the deontological approach, and the other is the forward-looking or the consequentialist approach. As you can see from this slide, how capital punishment has been meted out or continues to be meted out across the world. There are the countries that have abolished it are 109. Those countries which have abolished for all crimes except those which have been committed under exceptional circumstances, that include 10. Those which have not executed anyone during the past 10 years or more, around 23, and those countries which have gone on to retain capital punishment are 53 in number. Now we will come to the backward approach or the retributivist approach so far as capital punishment goes. The first approach or the retributivist approach, as I mentioned just now, goes back to the ancient biblical times and has been endorsed by mainstream philosophers right from the time of Aquinas, Thomas Hobbes to Immanuel Kant. These philosophers favored the backward-looking or the deontological approach. Their views were that as human beings are rational creatures, and as a result of this, they possess an inherent dignity. Therefore, anyone who kills another human being loses his right to life. Human beings have dignity as they are self-conscious rational agents who have the capacity to make moral decisions. It is this rationality that gives them dignity and a right to life. Taking the life of another innocent human being is evil, and the perpetrator therefore deserves to die. The retributivists hold three positions. All guilty deserve to be punished, that only the guilty deserve to be punished, and that the guilty deserve to be punished as per the severity of the crime that has been committed. There are many different versions of retributivism, but all of them more or less maintain a tight, essential link between the offence that has been voluntarily committed and the amount, form or kind of punishment justifiably imposed for it on the criminal. Retributivism regarding capital punishment often appeals to the principle of lex talionis or the law of retaliation, an idea which has been popularized in the ancient and biblical phrase as an eye for an eye and a tooth for a tooth. There are different versions of retributivism and they differ according to the interpretations of lex talionis or an eye for an eye. A classic expression of retributivism about capital punishment can be found in the late 18th century treatise written by Immanuel Kant, namely The Metaphysical Elements of Justice. In the treatise, Kant appealed to the principle of lex talionis and mentioned none other than the principle of equality. Only the law of retribution can determine exactly the kind and degree of punishment. Kant states, and I quote, "Even if a civil society were to dissolve, the last murderer in prison would first have to be executed so that each should receive his just deserts, and that the people should not bear the guilt of a capital crime and be regarded as accomplices in the public violation of justice." The basis for Kant to defend capital punishment is the principle of equality, by which the proper merited amount and kind of punishment is determined for crimes. Some retributivists have employed a less literal way of employing a principle of equality to justify death as the punishment for murder. The equivalence is simply one of harms and causes and not literal equivalence. Contemporary retributivists have interpreted lex talionis not as expressing equality of crimes and punishment, but as expressing a principle of proportionality. The idea is that the amount of punishment merited is to be proportional to the seriousness of the offence, more serious offences being punished more severely than less serious crimes. Now we look at the criticisms of retributivism as a policy of practicing death penalty or capital punishment. Retributivist approaches to capital punishment are many and varied. Retributivism with respect to capital punishment has often invoked principles that enforce only death as penalty for murder. The retributive approach has relied on principles that have been seen as inadequate because of lack of a proper method to map crimes with proper penal responses. The retributivists also operate on or with the presupposition that persons responsible for any criminal misconduct should be punished. However, instituting and applying capital punishment in practical circumstances is a different ball game altogether. The retributivist will have to demonstrate that actions done by the criminal were voluntary and that a fair and free trial has been conducted before awarding death penalty. Further, the retributivists have to answer various questions regarding whether any benefits actually accrue to anyone from the practice of capital punishment. What if capital punishment significantly increases the rate of murders or violent crimes? What if the institution of capital punishment sometimes, often or inevitably is arbitrary, capricious, discriminatory or even mistaken in selecting those to be punished by death? Now we look at the second approach, which is known as the forward-looking or the deterrent approach. The utilitarian approach justifies capital punishment by appealing to the consequences or effects of death being the penalty for serious crimes such as murder. The utilitarian approach is regarded as forward-looking or consequentialist, in contrast to the retributivist regarded as backward-looking. The utilitarian approach sees punishment by death as justified, and the reason being only if that amount of punishment for murder promotes the total happiness, pleasure or well-being of the society. The classical utilitarian approach to punishment was in fact developed by Jeremy Bentham, the founder of utilitarianism. In chapters 13 and 14 of his lengthy work, An Introduction to Principles of Morals and Legislations, which was first published in the year 1789, Bentham addressed the appropriate amount of punishment for offences, or as he puts it, and I quote, the proportion between punishments and offences. Bentham notably praised and acknowledged Cesare Beccaria's work on crime and punishments and its utilitarian approach to penal reform, as well as its call for abolishing capital punishment. Beccaria's call for abolition of death penalty largely by appealing to its comparative ineffectiveness in reducing the crime rate. Thus, for Beccaria, it is not the severity of the punishment, but rather its duration that goes on to have a greater impact on the human mind. Another major utilitarian, John Stuart Mill, also exemplified the distinctive features of the utilitarian approach. In an 1868 speech as a Member of Parliament, Mill argued that capital punishment was justified as a penalty for atrocious cases of aggravated murder. The utilitarian approach to capital punishment depends essentially on the causal effects of the practice, whether the death penalty was in fact effective in incapacitating or deterring potential offenders. The deterrence justification of capital punishment basically worked on a presupposition, and that was based on a model of calculating deliberative rationality for potential murderers. According to them, people value their life. If they are given a choice between life in prison and execution by the state, most people would prefer life and therefore would refrain from misconduct for which death was the punishment. However, even this forward-looking or the deterrent approach has had its share of problems. Now we look at some of the criticisms that have been leveled against this approach to deterrence. First, there is no conclusive evidence that capital punishment deters murder better than substantial prison sentences. 2. Deterrence and its effects depend mostly and most importantly on certainty, speed and public nature of penal responses to criminal conduct. Third, deterrence is a causal concept. The idea is that potential murderers do not kill because of the death penalty. So the challenge would be to establish a connection between what does not occur, that is murders, and establish what causes the omission, that is the death penalty. We will now look at different aspects altogether of capital punishment, and this has to do with the state's authority to legalize and guarantee death penalty. The contract theories of state authority believed that it is the individuals who gave their consent to abide by a governing authority and the laws thus formed were through mutual consent. Further, these theories, whether it be of Rousseau, Hobbes or Locke, have all stated and have all included the individual's consent to the practice of capital punishment in the created authority of the state to rule and to punish. A recent theory of state authority has also been developed by John Rawls in his book Theory of Justice. He stated in the book that a system of social cooperation is just if it would be consented to by rational, mutually disinterested individuals making their choice while ignoring particularities about themselves and their own place in the system. Summarization. Thus we find that the supporters of death penalty have gone on to argue along the lines that it is an effective way of controlling crime, as humans fear death more than loss of liberty. Further, executing a criminal is a better form of dispensing justice and making the criminal suffer for the wrong that has been done. The opposers have, however, stated that there is no direct connection between reduction in crime due to the award of the death penalty. Further, this form of punishment violates the inherent dignity of the human beings. Moreover, the question arises, why should one choose a brutal form of punishment to deter crime? All of these are questions that are raised in the debate about death penalty. Thank you very much.